Hi.
All right, thank you. Welcome back after lunch, everyone. We are continuing the testimony on Bennington one election. Today, we have legal counsel for Jonathan Cooper here. They issued a memo offering legal opinions. That is posted on our committee page. Members, you had time to digest that. We also have clerk of the house here, as well as our counsel, to help go through this conversation with us. So right now, to start off this block of time, I wanted to bring our clerk, Betsy Ann. There is a memo that she has presented to the committee. She's drafted for the committee, which is also on our committee page. Hit refresh because this just came in. If you have not refreshed your page. Madam Clerk, good to see you again.
Hello. Be here. Thank you. For the record, Betsy Ann Rask. I am clerk of the house and here today to discuss further with you your role in making a recommendation to the house on how the house should judge the Bennington 1 contested election. Thank you again for helping me out throughout the way. Mr. Chair, I have provided that memo to the committee. May I please share screen it? We can go through it together.
If you so wish.
Excellent. Thank you. And can we see this okay? Right. A little adjustment here. Okay. So I'm back here again. We talked last week. It's so nice being GovOps. I'm here again in my role as clerk of the house and as an attorney for the house in understanding the house's constitutional legislative authority and procedure. In my role here, I am not here to make a recommendation on the course that you should take. That's why I say you will have the hard job, because you have to make that policy decision. But what I'm here today is to help you understand the full scope of your constitutional authority in making this recommendation to the House. And when we talk about constitutional legislative authority and the scope of that authority, we look at not only the language of the Constitution, but we also look to case law because the Vermont Supreme Court is the final interpreter of the Vermont Constitution. And so we turn to its case law to understand our constitutional authority. And we have case law specifically on the Chapter 2, Section 14, power of the House to judge its member elections. And we also have a lot of other Supreme Court case law on the scope of legislative authority generally. And so when we talk about there being, when we talk about constitutional legislative authority and there being any limits, we need to turn to the case law. And so what this memo does is a follow-up to our previous discussion just last week to provide citations to case law regarding the constitutional authority of the House to judge member elections specifically, and also legislative acts generally, because that's also informative. And what this doc also does is provide some references regarding contested elections and some other contexts. So this is just to give some baseline information about the scope of your constitutional authority to judge member elections. So this section 2 is in regard to the House's authority to judge its elections being exclusively a House authority in accordance with what's called the political question doctrine. We'll get to that in a moment. Okay. So as a refresher, we talked about this last week. The Vermont Constitution in Chapter 2, Section 14 provides that the representatives of the House shall, quote, have the power to judge of the elections and qualifications of their own members. And again, we know from that 1983 case, Kennedy v. Chittenden, that this Constitution, quote, places the final determination of the election and qualifications of members exclusively in the House of Representatives of the General Assembly as part of its legislative powers. We know Kennedy v. Chittenden. We talked about it last time. That was a result of a contested legislative election where the lower superior court at first vacated the election results and ordered a new election until the Vermont Supreme Court swooped in and said, wait a minute, Chapter 2, Section 14 provides this power exclusively to the House. Judicial branch can't touch it. Okay, that was in 1983. Fast forward to 2001 to the similar Brady v. Dean case. We'll be hearing more about this later, tomorrow actually, by members of the House Ethics Panel. This was also in regard, also in regard to Chapter 2, Section 14. This was about the House's authority to judge its members' qualifications, but same principle, same section, same principle. House's authority to judge elections and qualifications. In that case, the court stated again that this court and numerous other state courts have held that where the state legislature is made the judge of the qualifications of its members by a provision of the state constitution, like our Chapter 2, Section 14 does. The legislature has the sole authority to do so, and courts must refrain from interfering in that determination, calling it the chamber's exclusive constitutional prerogative. Yours alone. So the court said in that Brady v. Dean case, we further conclude that as a policy matter, a proper regard for the independence of the legislature requires that we respect its members' personal judgments concerning their participation in matters before them. And in that case, they cited our lovely Kennedy v. Chittenden case, which they cited it there. The quote from Kennedy v. Chittenden in footnote 4 being that the Constitution places the final determination of the election and qualifications of its members exclusively in the House, rendering any attempted judicial intervention ineffective and violative of separation of powers. That's our baseline. And why? Why do they say that? This is a principle, as the court stated there, on both the federal and state level, of a principle of judicial restraint, when the court will not interfere with exclusive legislative determinations. When they will exercise this judicial restraint when a separate branch is exercising its exclusive constitutional authority. It's a principle called the political question doctrine. So I just provided a citation there from US Supreme Court case law that our Brady v. Dean court used to describe what is political question doctrine. All right, we'll just make a run through of this quote here. Prominent on the surface of any case held to involve a political question is found a textually demonstrable constitutional commitment of the issue to a coordinate political department, or a lack of judicial discoverable and manageable standards for resolving it, or the impossibility of a court's undertaking independent resolution without expressing a lack of respect due to coordinate branches of government, or an unusual need for unquestioning adherence to a political decision already made, or the potentiality of embarrassment from multifarious pronouncements by various departments on one question. What is all that saying? It's not the court's constitutional business. It's only the chamber's business to judge the election and qualifications, and courts are not going to question the outcome of that legislative determination. Paraphrasing. All right, so that's in regard to Chapter 2, Section 14 specifically. What has the court said about constitutional legislative authority and procedure generally? That's what this next section of the memo does, provides case law citations to describe the general authority of the legislature. And that is that the only thing that limits the legislature is a constitutional provision. That's it. The Constitution is not a grant of power to our state legislature. It's a limitation of its general powers. The legislature's power is practically absolute, except for constitutional limitations. And the court has said the standards for interpreting constitutional language and meaning, though related, are not the same as for ordinary statutes. Canons of construction, if applied, must be used more cautiously and sometimes differently for how the court will construe a statute versus how the court will construe or interpret a constitutional provision. This is so because a constitutional provision, unlike a statute, usually operates to limit or direct legislative action. It is of great importance to remember that since the purpose of any constitutional enactment is to delineate the framework of government, the working details are frequently left, as here, for a legislative definition. Interpretation, therefore, must not be so narrow as to present an obstacle to that function of the legislature carrying out that constitutional provision. More than one pattern of working details may well be possible and constitutional. And what has the court said about when it reviews legislative acts? Well, the court says it's not for the court to pass upon the propriety of legislative election to exercise its regulatory power, nor to question the wisdom of it. Our function is only to determine whether or not the manner or its exercise meets constitutional standards and violates any fundamental rights. So when the judicial branch is analyzing the General Assembly's exercise of its legislative authority, it presumes the legislature acted constitutionally. The court has said there is a presumption of a constitutional purpose on the part of the legislature, a presumption so strong, perhaps, as any that is not conclusive. It doesn't say otherwise. This has been stated repeatedly. And the court has said that every presumption is to be made in favor of the constitutionality of an act of the legislature, and it will not be declared unconstitutional without clear and irrefragable evidence that it infringes the paramount law. So this case law that I cited at the end here in those footnotes is in regard to when the court was reviewing legislative statutory acts, bills that pass into law. But it corresponds to what the court was saying specifically about your Chapter 2, Section 14 authority of judge member elections. So altogether, the court is going to presume that you are acting constitutionally in your decisions, and it's not going to strike down a legislative act unless there's clear and irrefragable. I had been practicing it so many times.
Pull that into my vernacular.
That they acted unconstitutionally. So with that baseline of your constitutional authority, basically, this is your decision to make. How are you going to treat this? That's why you have the hard job of doing this. But so that's our court, but it's backed up by other courts and other state practices as well. Here I provided some language from Mason's Manual of Legislative Procedure.
Yay.
Yay. You have adopted Mason's in accordance with House Rule 88 as supplementing parliamentary law. Mason's is adopted by at least 75% of the nation's legislative chambers to help supplement their law, parliamentary law, their procedures. And Mason's reiterates the principles of the political question doctrine in regard to a chamber's exclusive authority to judge member elections in Section 560, which is called entitled "Each House of a Legislature is the judge of the elections and qualifications of its members." So I won't repeat 560. It goes on for multiple sections, but I have Mason's here. If you want to review it or borrow a copy from my office, please let me know. But I just noted here specifically one provision of Mason's, and we talked about this last week, this concept that the authority of a house of a legislature to pass upon its membership is a continuing power. The question of the election and qualifications of members is never finally decided in the sense that a decision is conclusive upon the House until final adjournment. So you continue to have the authority to judge a member's elections. You're not under a time limit, although as more time passes, you can see might start to get a little stale. You want to resolve this quickly. I know you do, Mr. Chair, and so does the committee, and so does the House. But it's a continuing power. And Mason says that a member at any time may be seated or unseated upon the same facts. So I also want to note here the hierarchy of rules of legislative procedure as described in another provision of Mason's, Section 4-2. And we've reviewed this before, but this is just what controls your legislative procedure. Number one, it's the Constitution and judicial decisions thereon, as the judicial branch, the final interpreter. Then it's your adopted rules, and it's custom, usage, and precedents. Then it's statute. Then it's adopted parliamentary authority like this. And then it's general parliamentary law, like how legislatures normally go about doing. I wanted to point this out here because right now, there is nothing that describes the full range of your authority for how you can resolve this or make a recommendation for how to resolve this election. And actually, I think that's a good thing. For example, you would never put into statute how the House is controlled in judging a member election. Why? Because it's your exclusive constitutional authority. You have the continuing power to decide how to do that. And statute requires involving the Senate, our counterparts, and the governor, which, going back to the colloquial, not their constitutional business to rule or decide upon the House's authority. Not even our rules describe what your options are. And really, I think that's a good thing because you have a range of options in accordance with this general authority to judge your member elections. All right, so this memo is closing out here by giving you some examples in other contexts. So when you're judging a contested legislative election, the legislative chamber's remedy is dependent upon the specific issues raised in the petition for the chamber to judge a member's election. You know, what is the issue? What is the problem? What was the problem with the election or the results of the election that you're trying to address? So for example, we've had some more recent contested legislative elections were about the counting of ballots. For example, our last one in 2017, the proposed remedy that the House was going to pursue was a full recount because it was about how to count the ballots. And so the House was going to take on its own ability to recount those ballots, and to do its own recount. So, but that doesn't seem on point to what you're dealing with here, because here in the Bennington 1 contested a legislative election, it wasn't an issue of actually counting the ballots where they counted right. The issues raised were in regard to checklist irregularities resulting in voters voting in the wrong district that was enacted by law. So some of our more recent ones maybe not be on point. So you have to go back to what's your full range. So here's some examples just for reference. Going back to that sampling of past contested legislative elections doc, I'm just noting, and I provided that hyperlink there. Let's go back to the 1973 Senate Chittenden Smith v. Fayette contested legislative election, where the issue there was a failure to secure ballots between the general election and the recount, resulting in the judge overseeing the recount to refuse to certify the recount results. So that seemed kind of on point to what you are dealing with here about the final results. And one of those options, we talked about it last time, was the suggested referendum, where in this big Senate district, remember they had that special committee, it was that 4-member committee, they couldn't come up with a majority report. There's links in that sampling doc that'll take you to all the Senate journals. One of the suggestions there was to do a referendum from the town of Essex only. And then, let's see, I don't know if this will work with my share screen. It's not, I'm gonna do one quick thing dangling here, maybe not. Let's see. Well, if you go into that sampling doc, let's see, Mr. Chair, real quick.
Yes.
See if I can do this.
No, take your time.
I'm gonna stop share. I'm gonna share again. I'm gonna go
You have a
to,
big block of time for today.
right. How are we doing here? Yes. Oh, technology.
Nice screen grab.
All right.
It's even oriented correctly.
I know. Okay, so this is hyperlinked in that sampling doc, and this takes you back to that 1973 Senate Journal for that one suggestion on a referendum. Remember, they had that special committee that was formed. They couldn't come up with a majority report, so they had individual members making recommendations on how the Senate should ultimately judge that election. And so in this case, one of the suggestions was for a referendum. And here just lays out that suggestion from one of the members of the special committee to have a referendum where the recommendation was that an election in February of 1973, so after they got the session going, obviously, that there be an election held only in the town of Essex within the whole Senate district between the two principal adversaries. And they laid out how it would be conducted, and that following the special election, the total votes cast for each individual be added to the recount totals for each of the other towns in Chittenden County and combined to create the highest total. And then the combined highest total winner would be the winner of that Senate contested election. So that was an option. The Senate Journal indicates that to the end of accomplishing this election, I submit now to the secretary a so-called resolution for a referendum as previously described to the committee by the Attorney General as one approach, which he considers legally defensible. The hazards in this approach as described in the committee by the Attorney General are that an appeal might be taken in either of the contestants or by a citizen voter, an appeal of the election. So then he submitted this letter from Fayette, which was one of the contested, the people contesting the election, And this person was indicated that they're willing to support a runoff election. I'll just note here, they didn't decide to go after that option, but I'm just providing it for reference that that was one of the options. All right, Mr.
So it was heavily entertained, but they never went forward with the action itself.
Correct.
Okay.
All right, I'm taking us back. All right, okay. So that was one of the options in a similar circumstance. I'll just note the irony here is that in probably one of the other most similar circumstances for a contested legislative election was our 1983 Kennedy v. Chittenden contested legislative house election. And that's on pages 7 through 8 of that sampling doc, where the issue there, it seems like most similar to what we're dealing with here, was that in regard to voter qualifications, which was that 18 voters on the checklist did not reside in the legislative district. 10 of them voted, which was greater than the 5-vote margin of victory in that case. And I'll just note there that when the Superior Court in that case at first thought it had the authority and it was presented with this factual pattern, what did it do? It recommended that the general election results be vacated and order a new election. So before we knew that by the Supreme Court Kennedy v. Chittenden case, that Superior Court didn't have that authority. That's what the court thought was appropriate in that instance. Although, it ultimately did not move forward when the House ultimately judged that election. It ultimately allowed Representative Kennedy or Chittenden to maintain his seat, but there's no, basically, big picture, there's no indication in our Constitution that the judicial branch would have the authority to do that, but the legislative branch would not for one of its chambers, just for reference. But ordering a new election is a big deal. Here is what the Supreme Court of Vermont has said in the context of a different scenario, which was in the context of an alleged improper municipal legislative body. The allegation was that a municipal legislative body improperly influenced the vote. So we've got a 1997 Supreme Court case, Putter v. Montpelier Public School System. The complaint there was that a taxpayer challenged the validity of a city election in which voters approved a school system's operating budget and bond proposal. And the allegation there was that the school board spent public funds to promote passage of those proposals. And the petitioner to the Vermont Supreme Court asked that the election be invalidated, and the Vermont Supreme Court refused to do so in that context, stating in part as follows, that voiding an election and ordering a new one represents one of the more extreme remedial measures available to a court sitting in equity. Courts have frequently declined to order a new election where the governmental misconduct, considered in light of all the circumstances, did not warrant so extraordinary and destabilizing a remedy. And I think here that there's a subsequent Supreme Court case for another similar municipal election challenge where the court upheld that same principle of declining to order a new election when it was faced with similar allegations from a separate town. So this is just provided here for reference to say ordering a new election, if you're going to consider that as one of your options, is a big deal. And you have a lot of logistics to figure out if you wanted to do that. And also, I just want to note the difference between the Senate Fayette case in 1973, where the suggestion there, not followed, was a referendum where they were going to add those votes to the votes that they already had, versus this ordering a new election where you're actually vacating the election results and declaring the seat vacant. So just a distinction between two options that are more on the more extreme side.
I'm just looking at the Peter Putter versus Montpelier Public Schools, and I think just the word destabilizing, I thought was an interesting choice of words to put into the opinion.
And we know from our recent contested legislative elections that we haven't done that
Yes.
so far. Okay, so that was a separate Vermont set of circumstances on the municipal level. But thankfully, we have Congress also. Oh,
There you go.
yes.
Jumping in. No, no, no.
Question, thank you. This was specifically for vacating the whole election
Yes,
and which would destabilize
yes,
down the line. Okay,
yes.
thank you. I just.
And thank you for emphasizing that. Thank you for emphasizing it at that point, which is also something I want to emphasize.
Thank you.
too. Okay, but thankfully, we have Congress. What has Congress done? They have been at this long too, and they have more activity. So on the federal level, Congress has a very similar constitutional authority to judge member elections. So the US Constitution provides each chamber of Congress a similar exclusive authority to judge member elections as the Vermont Constitution provides the House. You know our language in our Constitution, Chapter 2, Section 14, the House shall have the authority to judge the elections of its members. Well, the US Constitution provides a very similar authority to each of the chambers of Congress. Our US Constitution in Article 1, Section 5, Clause 1 provides that each house, meaning each chamber of Congress, shall be the judge of the elections, returns, and qualifications of its own members. So here I've just provided some links to how each of those chambers has exercised that authority. The first doc that I provided here is a research document published by the Congressional Research Service, and I'm so grateful to them. It's a group of legislative staff that basically put out these research memos on a huge variety of congressional legislative issues, and they have one about how the House, US House, has exercised its authority to judge its member elections in contested election cases. So I provided a link to the congressional research memo on that, and I'm going to flip back, Mr. Chair. I should be able to do this here. All right, so you have links to this as well, and I'm going to go down to, this is a whole memo about this issue. A lot of it involves, the difference between the federal and state levels, since federal elections are conducted by the state entities, so there's a relationship there. But here, I believe it's page 16. This research memo is about some of the remedies that the House has been able to use when it has judged its member elections. So here they provide basically a range of remedies. A recommendation of dismissing upon a motion to dismiss, basically dismiss the petition. A recommendation to seat a certain candidate on the grounds that they received a majority. A recommendation to seek a recount and investigate any fraud or irregularities. Seating a certain candidate after the committee has conducted its own recount. They've done that on the federal level, just like we've done on our state level. And then finally, the last bullet point, a recommendation that the returns from the election be rejected and that the seat be declared vacant and a new election be held. So that has been an option, but look at that footnote and look at the paragraph that follows. So this research memo says, in the 1985 case of McCloskey v. and McIntyre, the committee noted that the House of Representatives has been, quote, very hesitant to declare a seat vacant, preferring instead to measure the wrong and correct returns when possible. The committee reiterated the general principle that, quote, nothing short of an impossibility of ascertaining for whom the majority of votes were given ought to vacate an election. Especially if by such decision, the people must necessarily go unrepresented for a long time. So remember, as you were just stating, Madam Vice Chair, we're talking about vacating the results. So the seat would be vacated and ordering a new election. Indeed, the committee in McCloskey and McIntyre characterized setting aside an election and declaring a House seat vacant as, quote, a drastic action that is recommended against in, quote, nearly every instance. But thankfully, that was the US House. And the next thing that I hyperlinked to was what happened in the Senate. And maybe this 1985 House perspective came from this 1975 Senate experience. So this is directly from the US Senate's website, such a great resource. And I want to thank here Legislative Counselor Michael Chernick for making me aware of this specific Senate constitutional, contested a legislative election. Apparently it was interesting times. And here, the US Senate page has a great summary of this closest election. And then I provided in your memo also a link to a more detailed version from the US Senate website. But I'll just end here with this one, or this last bit example to go over with you. So I'll just read it with you here. So this is from 1975, and this was described by the US Senate as the closest history. And it's from our neighboring state of New Hampshire. So in 1974, the New Hampshire race for an open seat pitted Republican Louis against Democrat John Durkin. And it led to a contest that lasted 8 months and came down to a margin of victory of just 2 votes. Is huge for a US Senate election. Okay, so they have this really neat background info. So although Wyman enjoyed a lead during the campaign, the Watergate scandals and the August 1974 resignation of President Richard Nixon made it a tough year to run as a Republican. On election day, Wyman barely won with a margin of just 355 votes in a US Senate race. Every vote counts. Durkin, the loser, immediately demanded a recount. The recount shifted the victory to Durkin by only 10 votes. Reluctantly, the Republican governor awarded Durkin a provisional certificate of election. Now, they say, it was Wyman's turn to demand a recount. The state ballot commission tabulated the ballots in dispute and ruled that Republican Wyman had won by just 2 votes. The governor canceled Durkin's certificate and awarded a new credential to Wyman. Whoa. Okay. So as a last option, Durkin petitioned the Senate with its 60-vote Democratic majority to review the case. On January 13th, 1975, the day before the new Congress convened, the Senate Committee on Rules and Administration tried unsuccessfully to resolve the matter. Composed of 5 Democrats and 3 Republicans, the Rules Committee deadlocked 4-4 on a proposal to seat Wyman pending further review. Another member voted with the other party on grounds that Wyman had presented the proper credentials, the other certificate. The full Senate took up the case on January 14th, with Wyman and Durkin seated at separate tables at the rear of the chamber. Soon, the matter returned to the Rules Committee, which created a special staff panel to examine 3,500 questionable ballots that had been shipped to Washington. Following this review, the Rules Committee sent 35 disputed points to the full Senate, which spent the next 6 weeks debating the issue and took an unprecedented 6 cloture votes, like to stop debate, but resolved only one of the 35 points in dispute. Facing this deadline.
I was still unpacking some of that. They went 1 for 35.
Big sure. Facing this deadlock, Durkin agreed to Wyman's proposal for a new election. Remember, they had gotten down to what, 10 votes, 2 votes?
Yep.
The Senate declared the seat vacant, and the governor appointed former Senator Norris Cotton to hold the seat for 6 weeks until September 16th balloting. September. A record-breaking turnout gave the election to Durkin by a 27,000 vote margin. And it had some political language at the end, which I'm going to ignore. So, wow, that must have been very controversial. And
Movie.
yeah, and then look at the difference between that original election and then ordering a new election and the result. Different set of circumstances. All right, I'm gonna go back to that memo and finish up. Okay, so those are some examples of how our chamber or our legislature has viewed its authority to judge an election, as well as Congress' authority to judge its election. So what's the point of all this? Just trying to assist your committee in understanding the full scope of the House's authority to judge this election, as described in both our Vermont Supreme Court case law, interpreting your Chapter 2, Section 14 authority to judge your members' elections and qualifications, as well as in Congress's administration of its similar U.S. constitutional authority. The remedy options are broad and are only for the chamber to decide. So I'm here for you along the way, along this very difficult task in figuring out what to do in this case. But please let me know if I can help you along the way. When you do get to a decision or to recommend, I can also assist you upon request for the procedure that you can use for that recommendation.
We appreciate you being on speed dial.
Yeah.
Can I see your hand up, Representative?
You should. Madam Clerk, the Fayette case, was that the only one where they isolated one town and considered an election in just one town of a district?
Based on the more recent tested legislative elections, that's the only one that I found where that was contemplated,
And they ultimately decided not to.
not to.
And what the reasoning or?
So that was an interesting one. If you want to go to that sampling doc, I'm gonna pull it up real quick. And thank you again. So the first one, I have to go back to a different screen. I just want to note, that first sampling doc that I sent had broken hyperlinks, so I had corrected them, and I thank you to Autumn for posting my corrected document with these updated hyperlinks. So let's go back to that Fayette case, in the Senate Chittenden District. So that was where Fayette won the general election, but then Smith won in the recount. And then what the Senate did was it established a special election committee, like this one, to make a recommendation on how to, the Senate should judge the election. And it was, in these links to the journal, it was a 4-4, it was a 4-member special committee. I think it had 2 members of the majority party, 2 members of the minority party, and they deadlocked. It wasn't a,
You're telling me it was an evenly membered committee? Like,
Yeah.
Remember, we talked about this the other day. I was like, wow, 4, that's a choice.
I guess, yeah.
yeah. So they couldn't get a majority report from their committee. And so it split off. 2 members of the committee, the chair and another member recommended this referendum. And then the other 2 recommended, I think that they, let's see, 2 other special committee members recommended instead that the recount results be affirmed. So the Senate did not go for the referendum idea. It was proposed but not pursued. The Senate Journal indicates that the AG had weighed in on the legality of the Senate to be able to do that. All we have is this 1973 journal entry,
Mhm.
which I clicked.
And at that time, I'm guessing that the makeup of the legislature was considerably closer. Have you any idea about how many each party?
I don't know. I can get that in.
I'd be curious about that. please.
Okay. Just waiting for this. There it is. Yay. Okay. So here, when you go to that hyperlink, there's a separate hyperlink that provides the that makeup of the Senate committee. Just don't have it handy, but I know it was a 4-member committee, 2 majority and 2 minority. And so it was that committee chair and another member that had recommended that referendum. But ultimately, as you can see in the final Senate votes on this matter, they had disagreed to that resolution that was offered to have that referendum. And they denied the Fayette petition, and they affirmed that Smith, who was the recount winner, was duly elected and qualified, and so Smith retained his seat. As you go through this sampling, and this is just the more recent ones that I've included here, and the more interesting ones, I have the whole list of all the ones that are known at this point. In all of the cases, except when the chamber has conducted a recount and found that a different member or a different candidate had won. They have maintained that the person who held the certificate of election was duly elected and qualified.
Anyone have any other questions? Madam Clerk, thank you so much.
Thank you.
Always enjoy your testimony and our talks on this subject matter.
Being here.
Just broadly speaking to our Constitution and how it applies to the work that we do. I appreciate you.
Thank you. I'm taking my bag this time.
Yeah. Handed that back to you pretty quick, though.
Right away. I said I felt very scared walking out of here.
Not tethered. Okay, so next I'd like to ask Tara Buxton, the attorney representing Representative Cooper, to come up and talk to us about the memorandum that was shared with the committee. We posted this yesterday. The committee's had time to digest this. Thank you so much for the summary as well. And yeah, we'll introduce, I know some of us have crossed paths with you in the past, but we'll do a quick around the horn with everyone. Representative Matt Byron, Chair of the Committee, Northwest Addison County.
Lisa Hango, Franklin 5.
Sandra Pincinel, Bennington, Rutland.
Michael Morgan, Randall, Chittenden District.
Hooper Berlin.
Bill Coffin, Windsor 2.
Mary Catherine Stone, Burlington.
Jay Hooper, Orange County.
Kate Nugent, part of South Burlington.
Hi, I'm Shay Waters Evans from Charlotte in Heinsberg.
And Representative Boyden is absent with a knee surgery. But she will be tracking the activity. So. Please.
Oh, great. So my name is Sarah Buxton. I represent Jonathan Cooper. I'm going to give you a little more information about myself, but while I'm doing some of these introductory remarks, I asked your committee assistant if any of you like paper. I know that I am ashamed to say I am a paper person. Some of you may be. So I brought copies of what is in your in the folder. So I'll just pass those around. And if you need one, take one. If not, I promise I will recycle.
No worries. And just for like future reference, I have a different perspective on these than my predecessors. So.
Great, okay. So thank you very much. For the record, my name is Sarah Buxton. I am first, really, I want to thank you all for your service. I am a former member. I represented the Windsor Orange District, now held by John O'Brien. So I was from Royalton and later Tunbridge for several terms. And so I really know how much of a sacrifice you're all making and serving the people of the state of Vermont. So thank you for your time and also for giving such attention, particularly to this matter, this election matter. It's important to all Vermonters. So thank you. And before I go further, I just want to let Mr. Chair and Madam Vice Chair know, they both know me and know I am a talker. Please do not hesitate to redirect me, to say, speed it up, move on, slow down, interrupt. I feel like this is going to work best as a conversation. And so I'm going to try to be engaging in that way. And I invite you to interrupt me, but I'm also very mindful of your time. So please, at any time, if you need me to redirect, I do not offend easily.
We have a big block of time. And
Terrific.
we bake all that into our calendar.
Terrific. So a little bit about me. I told you I was a state rep. I have 20 years in public service, both at the state and federal level. I've held appointments by both Democratic and Republican governors, most recently Governor Scott at the Department of Labor. After my public service forgiveness came through, thank you very much. I left state service just about 2 years ago and started private practice. I've been a lawyer since 2010, but I've never practiced in private law. So this was really exciting. And I landed at a wonderful firm up the street, Tarrant Gillis and Shems, one of the partners of our firm. Mike Tarrant is with me today. Mike also does a lot of election law and most recently won a Supreme Court case on non-citizen voting here in Montpelier. So we've talked a lot about some of the things we're going to talk about today. And he's also available as a member of our firm if you ever want to talk over ideas. Let's see, what else did I want to let you know? I'm also on the Mendon Select Board and Planning Commission. I'm on the state board for the Boy Scouts, now known as Scouting America. I really want to make sure everyone knows that. They are not just the Boy Scouts anymore. We are Scouting America. And that I have experience in election and constitutional law. I was a teaching assistant at Vermont Law School for 2 years, and I taught first-year students constitutional law and really, really enjoyed it. And then I have my own experience with election law. So you'll see both in my memo, and I'm going to reference it a couple of times today. It's not often a lawyer gets referenced their own case that it's actually relevant. But in 2010, I was in an election with a then sitting Representative David Ainsworth, who has now since passed. And I won on election night. We had a recount and it brought it right down to 1 vote. And Mr. Ainsworth came and we went through this very same process. So I know how it feels to be in Mr. Cooper's shoes and Mr. Bruce's, because later on I was in Mr. Bruce's shoes. So we had that election. The House did find that I was qualified. And then, you know, a mere few elections later in 2016, the table was reversed. And so I thought I won an election night. We had a recount. It was tied. And it, by the way, it's the only time right now in statute that the court can intervene and call for a new vote is when there's a tie in a general election race. So it was up to me and my colleagues and my attorney at the time to decide whether we wanted to go forward and ask for a revote. This was only a few weeks after the election, and we opted to just do another revote. And I will tell you why I feel very strongly that that was the right decision. I lost. The revote came back and I lost by 1 vote and later by 2, but I absolutely think that was the right thing. That's what the voters decided and we got to the bottom of the matter. So, all right. So
Specific to a tie.
but yeah, exactly. Specific to a tie is when the Superior Court can order a revote. And there are timeframes that sort of attend to that circumstance. So my job today is I am Rep. Cooper's lawyer. But this is not a court of law. I am here, and what I'm specifically trying to do and what my memo is trying to do is to respond to the 4 petitions that your committee is considering. I am going to give you my perspective and our perspective on what I think your committee should do. And I'm going to lay out the legal reasoning and the legal analysis for our positions and our recommendations. I hope that what you hear today is that my recommendations are not in conflict with at least what I have heard so far from your wonderful counsel, both Madam Clerk and also I think, is it just Tucker, or Tucker's the only one that you've heard from so far?
Yes, sir.
Attorney, okay. So I don't think that what I'm recommending to you is necessarily in conflict, but it is a way that I think you could move forward with making a decision. I serve as not your counsel, but I feel like I'm here in a role where you should feel comfortable challenging me and asking me questions the way that a judge might say, well, counselor, why do you think that? And what is the basis for your recommendation and your analysis? And whether I can do that on the spot, which I hope I can do for you today, or I say, may I, look at that, brief it for you and give you some more information. I too am willing to help you think through what it is that you want to do. Ultimately, you will be the ones that have to provide that recommendation. I'm very well aware of that. And just like most matters that your committee touches, this is far from simple. And so just from the outset, you already know, I know you've been looking at this for a few weeks now. It is very complicated, both in terms of the law, because there's some scarcity in the case law, but there's, as your clerk just demonstrated, there's a whole variety of opportunities for you to exercise your power. And so it presents a lot of areas for something that should be potentially simple to be extremely complicated. And I argue that your power is to use your best judgment in deciding what the legal arguments are and what is persuasive to you, as well as the policy. And we can't forget that politics are a part of all of this. So before I move into my argument, I will say one thing on politics. Rep. Cooper and I both come before you with our memo and our recommendation and strongly believe that the politics of this should not be part of what your committee looks at. It doesn't matter what the letter is at the end of that person's name or what the parties feel. I think we, my client and I are coming to this thinking that you have a really important role. And as you analyze this situation, what I'm hoping I can provide for you is an analysis that is devoid of the fact that it's a D or an R that is petitioning, and helps you to make that decision, not based on politics, but on all of the other factors we've talked about. Okay, so I am not going to read that giant memo that I gave you. I'd like to think that all of you have definitely read it and clicked on all of the links and read the cases.
I asked them to at least. Study all the time.
I'm happy to answer any questions on it, to discuss or debate any of it. I'm quite aware that your time is very valuable, and this weekend you probably had a lot of things on your agenda. So I also presented the executive summary. And so it's kind of the executive summary that I think I'm going to frame my probably next half hour with you today around. And what I would like to do is I think I've got 8 arguments that would support our position. And I'm just going to touch briefly on each of them, give you a couple of reasons why I think those arguments should be, carry weight. And I'll invite any questions along the way. I love that you've just already spent a little time with the Putter case, because I was going to cite a little bit from the Montpelier case about voting elections and the issues that surround that. So that table has already been set. So let me begin with what we are asking for you to do ultimately. After you've heard all of the testimony and you've considered all the arguments, Rep. Cooper and I are respectfully asking for you to find that he has been duly elected and is qualified to represent the Bennington 1 House District. And that really is the action, while you have many opportunities to act in front of you, as you've heard, that is really the core of what I think the decision is before this committee and the House was he duly elected and is he qualified? And so I'm going to argue that he was, and you should find him so. I also, at the end, want to acknowledge that there are some claims and some injuries from all 4 petitioners, from Mr. Busa, from the towns, and from the Pownell 45, that perhaps need to be addressed. And I think that can be addressed through a separate process. I'll give you my recommendation on that at the end.
We got into the Pownell 45 just as sort of like a tag, like an attachment, right? So there wasn't actually like 45 people in that, right? Isn't that sort of an interestingly
Yes.
as a numer?
As a side, I did take out the list of the Pownell 45 and I compared it in consultation with the town clerk with the number of voters that were determined by the BCA to have been now on the now in the District 5. So moving from District 5 to District 1. And I will say, to the degree that you decide that you want to depend on the veracity of the Pownell 45, I have already found at least 1 error or 2 errors.
I'll let you get to that. I'm just
Okay.
was just sort of calling it that. I'm struggling with that because it's an inaccurate number, it appears, right? Like it's actually 20 something.
Oh,
Well, there were 56 individuals.
Yeah, clarify that for me, just because people are asking me about this.
Yes.
And I want to make sure that I'm like painting the picture correctly.
Yeah,
Yes.
exactly. So there was a finding that there were 56 voters who were on the checklist who should have been voting in District 1.
Right.
And so this Pownell 45, what I can't quite discern is the number of people who've signed it, who've set their name to it, but the numbers, you're right, don't add up. There were 56, and now in consultation with the clerk, I know there's at least 55 because one person, it was an error that the BCA will likely have to go back and fix anyway. And even in the 45, one of the folks that I asked her about, she acknowledged that, his name is there, but he's moved out of town. He had been challenged. He didn't vote. And so there may be some error even including this one person on that list. So you're right that there, I think, still needs, if you decide to go down that path, you'll want to get a little bit more clarity on the exact numbers. And I can help you with that because I started to do that homework.
Yeah, I was just being more to sort of like the
Yeah.
end of it, right? Like, yeah, so
Yeah.
thank you for that.
Yep, lots of numbers. All right, my first argument has to do with the thrust of what you were just discussing, and that's the scope of your constitutional power. So I'm going to argue to you, and I think I stand on really solid ground, that ordering a revote is likely an unconstitutional use of your power because the plain language of the Constitution directs the House to judge the past elections of its members, not to create new elections that you can then judge. And so you'll see one of the handouts, I'm sure you've probably already had a chance to look at it, but one of your handouts is the one page of the actual language of section 14. And you will see that it says the representative so chosen shall have the power to be judge of the elections and qualifications of their own members. And many of the cases, including Kennedy and the Brady v. Dean case, the qualifications and the elections have been, those words have been used, they've been conflated together. And what I'm arguing to you is that when you review and think about an ambiguity in the Constitution, that you should resolve it in a way that doesn't result in an irrational or absurd result. And I would say to you that it would be irrational or absurd to think that the framers of the Constitution meant to so readily convey to your body the ability to do this in a very partisan body and call a new election of a member who was just sent to Montpelier by the people. I think it's different with qualifications, and I think Mason's further describes how your power to judge the qualifications is an ongoing and can look back into the past. Was a person qualified to actually even get on the ballot and to be here? And have they done something that disqualifies them from continuing to serve? I would agree that that is a power that you have that looks backwards and continues forward. I would say that your power to judge the elections is a retrospective one. And so while, there are perhaps some limitations on who could challenge you if you do decide to exercise that power, and there isn't a lot of case law for us to predict what a court would say about your exercise. They may say political question. We're not going to get involved. So that could be the case. But I'm arguing to you that as a person who is reading this and says that I think there's some ambiguity here, I would read it to say that that part of your exercise, because we're talking about an election and not about the qualifications per se of Mr. Cooper or Mr. Boussa, but about their election, that is a point in time, and it doesn't mean that it extends to you're calling a new election and then being judge of that. I think I'm arguing to you it's a retrospective power. So that is my first argument regarding the use of your power. Closely related to that is this notion of custom and precedent. And as you just looked through with your review of many elections at the federal and state level, at the federal level and at the state level for over 200 years, there have been contests. And the power for a losing candidate to petition the chamber that they want to belong to and say, be the judge of my election or my qualifications. They have looked at and reviewed this issue. And the custom has been of those bodies to exercise restraint. And they have considered, as you've heard and discussed already today, that maybe we do have the power to order a revote or to vacate an election or to offer some other kind of a remedy that might change the outcome of an election, but they have refrained from exercising that power. And I would urge you as the committee that is going to make a recommendation to the House as a whole, that you would first consider the custom of the past and take to heart the gravity of your role and the consideration that I think you need to place on that decision and what it would take to break with custom. I also think that if you were to set a precedent and break with tradition, and you would order a new election, that you would be opening yourself up to repeated political partisan requests going forward. I think once you go down this road, it is a slippery slope. And I'm also going to talk about public policy in a moment, but this is closely related. Elections are so important, I actually think they are the most important thing that the Constitution sets forth and that it protects. It is how we govern ourselves. They are so important that you must be protectors of a process that doesn't invite troublemaking for partisan voting. And I do think that if you were to order a new election or a revote of some sect of that group, you would then be saying that if someone is dissatisfied with an outcome of their election, regardless of whether it was close and they had a revote, this power to petition you is not very limited. And you will then be putting this committee specifically at the heart of spending your first month or 2 months of every single biennium working on these issues and trying to pull back that decision that you've made and trying to maybe refine what are the boundaries, what are the circumstances that we would order a decision to go back to the people, back to voters months after the election has taken place. So that's my second argument of 8. Pause for a second.
Did I see your hand?
Yeah, I'm curious, retrospective judgment versus what I guess I would consider active judgment. If there were a revote, it would be the judgment of the voters.
So it would be, but I would say that your power is to judge the elections as in the elections that have occurred and not the elections that will occur in the future. I can see where another lawyer could argue, oh, but I do think, just like I was saying, qualifications is temporal and it can exist going into the future as well, and it is ongoing. But I think that if the framers had intended this to be looking forward and not retroactive, they would have perhaps maybe put a few more words in this section of your power to limit your ability to simply call for re-elections at whim. And so that's what I mean by retroactive. I think that your power is to look at what has happened for the elections and to say up or down, and not to order new elections and then say up or down.
So that would be part of the process. We then confirm the outcome.
Well, I'm speculating that I think what some of the petitioners have asked is that you order a new election.
Right.
And then you would say, if you were to agree with that and order a new election or a revote of some kind, that what you would be doing is you would have to, I don't think there's any other way but to vacate a previous election. And to do that, you would be voiding all the votes of the past. You would wipe the slate clean and say, here is a brand new election on such and such a date, and the outcome of this election will determine who we as a committee will then judge to be qualified. You know, it's like an advisory opinion in my view. I think it's an advisory opinion when you go to the voters and you're saying, new election, by the way, we still haven't judged on these petitions, but why don't you just let us know what you think? And then we'll go from there. Nuanced, novel,
yeah,
complicated, and probably can be argued, back at me.
Yeah.
but that's what I'm positing.
Understood.
Third big important thing to consider. Checklist errors, as I believe Madam Clerk knows, checklist errors are addressed by a very detailed statutory process designed to occur before Election Day. I noted my work at the municipal level and also my work as an attorney representing municipalities across the state, because as you're probably all aware, there are many examples in municipal law where clerks are required to provide notice. And it's notice of meetings, it's notice of a ballot, it's, making sure that everything that is done is transparent. If we are to say that notice and the opportunity to seek redress during that notice period can be usurped by this process, then we're basically saying to them that notice really isn't important, but keep jumping through the hoops. Keep doing what you're doing, be transparent, but no one's going to have any incentive to react to what they're supposed to be reacting to that they have notice of. So I think that this election needs to be upheld because it was conducted according to the law. There are requirements that the checklist is posted. There are requirements that it's made available to parties, to candidates, to voters. It needs to be posted outside. The ballot needs to be posted outside. And there's a board of civil authority that makes decisions. If the clerk got it wrong or some voter was registered to vote and they were, presumed to be eligible, put on that list, there are opportunities to change that. And that process is codified, and this body has spent a lot of time codifying it.
One moment, please, Counselor.
Yes.
Shane, Representative Rogers Evans.
So as far as the notices and the checklist sharing and the posting and all of that, has it been verified that all went correctly?
Yes.
Okay.
Yes, I'm relying on the investigation that the AG conducted and also just my verbal conversation with the clerk.
Okay.
Only the clerk of Pownell, I will say. I did not have the same conversation with the other clerks. But the clerk of Pownell, it sounds as though the checklist was posted. And when I say posted, it was posted for 4 elections. 4 elections. 2022 primary, 2022 general, 2024 primary, 2024 general. So yes, I found it to be verified in all the inquiries that I've embarked upon.
I just want to add that what happens is, I believe it's 60 days before an election, your updated checklist in 5 places within your. So, and so it's on the voters to check that checklist at the post office or in the town clerk's office or at the town, community center to see if your name's on the checklist, because sometimes we take people off because we believe they've moved out or haven't voted in 2 general elections. So we have the authority to take them off. So it's the onus is on the voter to make sure they're still on the checklist. So each one of those elections was a new checklist. It wasn't always the same checklist posted.
Understood.
So I just want to.
No, that's a great point to raise. Thank you.
Right, so is that, if I'm not mistaken, 5 is more than usually 3? Usually you have to post it 3.
Depending on the size of your town.
Yeah,
Yeah.
so it is, the intent is to make sure that everybody has an opportunity to look at this. They have an opportunity to review. They have an opportunity for redress. In a court of law, what we would say is that if you haven't raised your claim during a period where you're allowed to say, hey, I claim injury, you've waived your right to redress. And I would say this is a case like that we've had 4 elections. We have government officials who there's no evidence of malfeasance or any type of political partisan gamesmanship. There were errors, but I have not seen any evidence of any malfeasance. And I would claim that those who are now seeking redress have waived their right to that because they had the opportunity. Now, I'm not a sports person, but I'm going to try a sports analogy. So please help me out here if I get it wrong. Pick your game. I'm just gonna pick soccer. Actually, I picked field hockey because I actually played field hockey. During field hockey in a game, there's a bad call. Ref makes a bad call. We stop the game. We talk to the ref, not we, not players. The coaches do. And there's a point where the ref might confer, they might make a decision. The decision is made, you continue to play. When the game is over, the game is over. I would argue that as a society, we believe this, that in sports, there needs to be finality, and there are times when you raise objections. When the game is over, it is not the time to raise the objection. I will say elections, there may be some circumstances, not in this case, but there may be some circumstances where that merits raising an issue. A similarity in this case is if we played, the Barry Auditorium, right, basketball games, you've got three, Division 1, 2, and 3, all playing at the Barry Auditorium. Games are won and lost by 1 point. Folks are walking out of the gym. The next day, the janitors are sweeping the floor, and one guy walks back in and says, the court is 4 feet below regulation. I don't know, small or large, right? So what do you do then? Everybody played on the same court. Nobody challenged it. Everyone had the opportunity to walk around the court. Do the losing candidates or losing teams get to say, hey, we need to play again? Do you only get to play again if you lost by a point or if something happened in the game? So I think I raised the sports analogy ineloquently, only to show that as part of society and our values, we already believe that there's a time and a place to raise your concerns. Opportunity for redress, that was my third argument. The fourth is public policy concerns. I think if you were to order a revote of any kind, a small group of people, the whole group of people, 1 district, 2 districts, whatever it may be, that you would be setting a precedent and you would be creating a public policy that enables people to turn a blind eye to the attention that they do need to be paying to their elections during the time that the election takes place. So I think we all have a collective responsibility to participate in the technical aspects of verifying a checklist. And if we're going to say, in the future, if you didn't really pay attention, why don't you just come to us after the fact? What will result, and I'm being a little cynical here, is we will have parties and candidates who will look at that checklist and make a calculated decision about whether or not they want to point out an error. And possibly they'll wait until the end of the election and see what the results are, and then come and say, wait a minute, there was an error. And so I think as a matter of public policy, if you were to go back and you were to set this precedent, you would be enabling that as a matter of public policy to continue into the future. And I think it's important enough that we tell our citizens and we require our citizens and our parties and our candidates to pay attention to the checklist, that I think you should avoid dabbling in that direction. Halfway down. Disenfranchising the voters. Creating a new election by operation of law would void the votes of the voters. You just heard a really great quote from that Putter case. I'm going to read one more sentence, and I'm happy to share the case or the citation if you want to read it. It's rife with a lot of good quotes, but this is from our Supreme Court. It was from 1997. It was here in Montpelier. The court writes, as a result, courts reviewing election challenges have established a high threshold for what one court has described as drastic, if not staggering, an equitable remedy of election invalidation. The setting aside of an election is an extraordinary remedy, which the court should grant only in the most extraordinary circumstances. Things like the dilution of votes through malapportioned districts, purposeful or systematic discrimination against voters of a certain class, or pervasive election fraud. or other willful conduct which undermines the organic process by which candidates are elected. So those are the categories of conduct that I think might be something. If we had any of those examples here in this case, I'm really arguing that some of my previously stated arguments could be usurped by a gross miscarriage of justice, this willful conduct, pervasive election fraud. We have none of that in this case. And so our Supreme Court, which is not anything you have to follow, as your clerk noted, you have the power to set your own path. But I think it's instructive to see where other bodies have made this consideration and had to weigh those facts. Finally, I'll just say on this topic, I noted that I also had the opportunity to decide in a court of law whether we wanted the judge to order a revote or just count the votes again. And so from a very personal level, knowing that you're in the first week of December, and that's already a month past the election, we really had to think about our voters who were away, who were perhaps unavailable for a revote around a really inopportune time, like Christmas or New Year's or whenever it would take place. But to me, I think what was more important is that you had voters who came out on election day, who all made a decision to vote or not vote, and they cast their ballot. And I think that they were owed the respect of trying to see if we could find a way to make their vote count. Again, it did not work out in my favor. I would not do anything differently, but I would just urge you to really think about disenfranchising those voters who came out on election day and the impact that calling a new election would have by voiding all of those votes and starting anew. Number 6, these next two arguments are really about the specific circumstances in this case. There is no fair way to conduct a revote. We've talked a lot about checklists, and I think what this committee hasn't really dug into quite enough in my view, so I'm going to raise it now, is that checklists create a presumption of voter eligibility. You have no number right now in front of you. You have no knowledge. I mean, there's no possible way to know how many eligible voters there actually were on election day and there are now. Because in Vermont, you can show up on election day and you can say, I would like my ballot. And there are only 2 reasons why you can be challenged. 1, you voted in an election in the past, and 2, you aren't who you say you are. And maybe a conversation for a different day with this committee, but under our current law, we don't have a way to actually know how many voters there are. So if you were to say, oh, there's 56 votes or 43 votes or 45 votes, and that would determine the outcome of an election, I would say that you actually don't know how many new voters there are. Whether you choose to say on election day or on March 15th is when we're going to vote, because people move in and out every day. I myself have been living part of my time in Montpelier for 2 years and part of my time down in Mendon. After election day, I've made the decision to still have my apartment in Montpelier, but to become a voter in Mendon. If Representative Casey was the subject of this petition, I don't think it would be fair that I could, even if you said, let's go back to whoever was eligible to vote on election day. I moved out of town. Like, I'm not eligible to vote in Montpelier anymore. Should I be allowed to vote for him? I would say no. I learned from the town clerk that there has been some movement in and out of the district. So my overarching argument to you is that there's no fair way to conduct a revote because the actual number of eligible voters in Bennington 1 and Bennington 5 isn't known. And in whatever configuration you would order a recount or revote, whether it's some or all of the district, you would still have an inaccurate result. We haven't talked a lot about the fact that there are these 56 people who are now eligible to vote in the district. There were 14 voters who voted for Cooper or Busa, or 14 eligible people on the checklist. I think only 8 voted. You would have to take them out. So I don't see how you could have, without having a vote of the entire district, I don't see how you could operationally order a solution here that wouldn't still either disenfranchise someone or cause problems with people's eligibility to vote. You know, you'd have to pick a point in time. Some people would be eligible, some people wouldn't. Your grounds for even challenging the voters at that point, I mean, all you can do is challenge them on 2 things under the law. Are you who you say you are? And did you already vote? Well, technically, they already voted in this election. Every single person already has. But even if you want to not withstand that with your grand power and say, well, notwithstanding that, we're just going to consider you all to have not voted for the purpose of that challenge, no one can be challenged on where they live. Wasn't that the whole crux of this problem? Like, what side of the road do you live on? What checklist should you be on? Who are you, what race are you eligible to vote in? So I think you're faced with a lot of bad options. That means.
She said that to a couple of people.
Oh, you did?
Yeah, I mean, it's just like a series of like.
It's really difficult.
Yeah, there's no like golden choice here, right?
Yeah, exactly.
Yeah.
And so I'll say my final one is that elections require finality. I think I've kind of touched upon this in some sense. We've seen this play out at the federal level, starting back with Bush v. Gore, and then 4 years ago, and there's been a lot of conversation about the fear of this last, federal election and whatever that may be. Elections do require finality. And I know what it feels like as well from a personal level, being in office, being seated, taking your oath, trying to work, and yet in your weekly reports back home to your district saying, hey guys, I'm really, really working hard for you. What can I do for you? But there's a cloud hanging over your head. And to the extent that I'm sure we have wonderful chairs and vice chairs all through this body, this biennium, who would certainly give Rep. Cooper any opportunity to bring a constituent issue forward in this sort of uncertain time. But it still is uncertain. What if something happens and Rep. Busa becomes your new rep by April? I think elections require finality for the voters in House District 1. They need finality. There needs to be a timeline by which decisions are made. I will note that in the case that was cited with the judge, in the Kennedy case, when the court before it was decided that they didn't have the power to order a revote, and the court had ordered a revote, that was in like December. I'll double check that, but I'm pretty sure it was within weeks of the election. We're not talking about 6 months later. And so finality, when you do have these opportunities for revotes currently in statute, it is within you've got 15 days to appeal, you've got another, 10 days to take a revote, and things finish up so that people can take power and, carry on with the operation of government. Those are my 8 arguments. I'm now going to pause, and then I want to tell you what I think your other best equitable remedy is. Any questions?
Table.
Okay. All right. This is new and novel, but I think it's sound, and I think this is based in an accurate and well thought out reading of the Constitution. So in section 73 of the Vermont Constitution, the General Assembly has the power to establish representative districts within and including all of the state. This is reapportionment. It happens every 10 years. And under the plain language of your constitutional grant of power, you have the power to redraw the districts every 10 years, and I quote, at such times as the General Assembly finds necessary. Has it ever had to do that in the past? Sure thing, back in the 1960s, when the US Supreme Court said one person, one vote. Hasn't really happened ever since then. It is not something I would argue should happen regularly, but the equitable remedy that I think that this body can put forth for the petitioners, who I am sympathetic to, who said, but I cast a ballot for someone who isn't going to be representing me, or I didn't get a ballot for someone who is representing me in the state house, is to go back and to redraw those district lines to what the voters and the BCA and the candidates and the political parties and the General Assembly and the AG's office and the Secretary of State's office thought that they were back in 2022. At that point, you eliminate any question as to anything that happened in the last biennium with the duly elected representative. And more importantly, to the extent that the voters who participated in this election had a say in the person who's representing them in Montpelier, you will have corrected that going forward. There are mechanisms by which you can do that. It could be as easy as working with the BCA to say, what were the lines? Let's go back and do that. You have the Legislative Apportionment Board chaired by former Representative Tom Little, who I'm sure could come and tell you that they could provide something for you to look at, and then draw it according to that. But I think that that is the equitable remedy that provides the petitioners with the relief that they're seeking, and it allows you an opportunity to move forward with this election and to put it behind you, to not set any bad precedent, to stay true to House custom, and to choose the best of a lot of difficult choices.
Senator Waters Evans.
So what would you say, just for fun, asking this question, what would you say then to the slippery slope argument that you made earlier about, changing the election and stuff? How is this different if you say this didn't go well, we're going to redraw
districts?
Right. So how does that apply in that one case, but not in this case?
Yes. So I think there's a few in the case before. I think there aren't any guardrails in place. In this case, you can set some guardrails yourself as you embark on this initial journey. And the Constitution says at such times as the General Assembly finds necessary. I would urge you to be very clear about why this is necessary, and thereby instructing future House members or Senate members, the General Assembly, on what should be the level and of need for this to happen. What should be the process? What is the analysis? I would also say that you could point to the fact that if we're talking with Rep. Hooper about retrospective and prospective activity, and in this case, it is retrospective looking. Like, you have a finding that people genuinely believed and thought they saw their names on a checklist. They presumed it was accurate. They got their ballots and didn't think differently about what needed to be done. And so I think that you can prevent the slippery slope in this circumstance in the way that you exercise your power by creating all of those guardrails in what you put forth. But you're right. You open the door. You've opened the door. Another body that could say, oh, but this is like this in this way, of course. But I think this is an extreme, rare, weird situation. And this is the best way to try to get everybody back to whole.
Representative Hango.
Thank you. So in the case of your equitable remedy, Am I correct in saying that what you're telling the voters who did not get the opportunity to vote for the candidate of their choice by having that printed on their ballot? I understand that they could have written their choice of candidate in the blank spot. You're telling them that they are not disenfranchised because they did get to vote, and that we're just gonna redraw the boundaries so that their new district is the district that they actually voted in.
So I would say that what I would be telling those voters is on election day or whenever you got your ballot mailed to you, presented to you, and you believed that this reflected your slate of eligible candidates who would be representing you for House 1 and House 5, that what you believed is true. That those were the candidates. And yes, your vote counted. And that election reflected what the district actually is retrospectively. So I don't think I would be saying, because I think what you may be trying to say, if I can, just checking my understanding, I think what you're saying is, wouldn't somebody say, you're disenfranchising me because why?
Because I didn't take the time to check the checklist to make sure that I was in the right district.
Right.
So it's putting
Right.
the onus on the voter, him or herself.
Right.
And so we're going to remedy that by redrawing the lines. So you actually weren't disenfranchised. You were voting for the candidates that you should have had a selection between, should have had a choice.
Right. Right. So I would say that I don't think that a voter would have, what I would say is what you believed to be true was true. You trusted your election officials. Yes, I previously argued and still believe we all have an individual and collective responsibility to make sure that elections are administered and checklists are fair and accurate. But voters do trust that when they're handed a ballot, it says who you say it is, or it says who are eligible to vote for. If I'd gotten a ballot that said Elise Stefanik, I probably, only because it's a big race, you kind of know your one congresswoman option and, Becca Balint, if her name wasn't on there, I'd say, that is a little weird. But I get why at the local level, I myself do it too. Sometimes I don't know who that person is. I get why someone might feel that way. But I don't think that by redrawing the lines, you're doing anything but saying to that voter, when you trusted us and you believed that that was the district that you needed to be voting in, and those were your choices, they were. And you exercised your vote, and we heard it, and it was counted. And that's how I would respond to a voter who might feel like this was working against them in some way in their power.
And then to say to the folks who actually knew that there was something wrong and wrote in the candidate of their choice that should have been on their ballot, what do you say to them? Okay, we're redrawing it and your vote is kind of invalidated.
Yeah, well, so you're raising an interesting point that I would say hasn't been presented to me in the fact pattern yet. So I was listening to the AG's testimony and listening to I have not spoken to every voter, obviously. And I did see, there were folks in Ben 5 who voted for Jonathan Cooper and Will Greer. Neither of them are, I think Rep. Pincinel, you mentioned, people sometimes do this. And so I would say to those voters, if you had the wrong ballot, why didn't you say something first? But I don't know that we have any evidence that anyone did know or take action. The story, as I've heard it through the different sources, including the clerk the other day, was that it wasn't until November 8th that the issue was raised. And I think, just speaking with Mr. Busa, he told me, which isn't part of the record, that after the election, he did have conversations with people who were like, I thought I was going to vote for you and I didn't see it. But to the extent that that has been part of any findings yet, I don't think that's not part of the fact pattern, but I appreciate that if they saw something wrong, see something, say something, and that goes back to my opportunity for redress, and that we can't have public policy that allows for only raising an issue after you've seen the results. And I'm sympathetic that it feels like government was a bad actor in this, and I'm saying government can be the good actor to make it right.
Representative Hooper.
You just put a nail in something for me when you say government should make it right. It seems like with redrawing and revoting, we're validating what was wrong. And I had looked at this from the beginning and still have a tendency to look at it as the only people that were wronged here were the ones that were denied their suffrage because we sent them the wrong ballot. Several of those people did not exercise their right to vote. The ones that did exercise their right to vote are 45 or whatever number that were wronged. And my keep it simple solution was give those people the right ballot and let them revote their election day because they were wronged on election day. The people who decided not to exercise their suffrage basically have no harm, no foul. That just seems like the simplest thing to do, even though there was a mistake made.
Yeah.
It wasn't your response.
So I think, through 3 or 4 of my arguments, I hope that I've at least piqued your interest in reasons why I firmly believe that a revote or to some or all is the worst of all options, because it will both disenfranchise people. It still will result in an unequal result. You don't know who the eligible voters are. The rules by which the game will be played are going to have to be rewritten. You don't have finality. I don't think just simply providing them with a ballot is a good solution. I think it makes a bad situation worse. And I would say that if government without malfeasance did something wrong, didn't have the correct checklist, there were statutory opportunities under statute for this to be discovered by candidates, by parties. All of our parties, whatever party you belong to, have voter lists. They upload this stuff. They've got data that is like scary. And nobody figured it out. And I feel like as a collective society, we have to, just like with the field hockey game, we all played by the same rules. We played on the same field. The game is over, and there are greater interests that need to be weighed at this point in time, including the ones that I've mentioned, and that the best result is to verify the winner and allow all of those who were injured in the past, injured by meaning their vote, as Rep. Pango said, their votes were cast for people who aren't actually representing them or vice versa, to say, we're making that right. Your votes were cast for a person who is now representing you, and they're going to be calling you and asking what you want them to do. And I think redrawing that line is your solution. Going back to what the BCA and the town of Pownell believed the line to be, it also, in terms of deviation, better balances out the districts. You don't have a problem where the deviation between the two districts, you have they're never perfectly aligned. And in this case, the numbers work out beautifully. So if you look at the memo, I actually have exact numbers. So the Bennington 1 district is over by 126 voters. So they have a deviation of 2.94%. Conversely, Ben 5, which I think is Rep. Morrissey and Rep. Nigro, is under by 5%. So they have 430 fewer voters than they should have according to all these, these calculations. If you were to take the roughly 50 voters or so, whatever the number actually turns out to be, and put them into Rep. Nigro and Morrissey's district, you're evening the scales. They go from being under by 430 voters to being only, sort of a little bit small by Math and Public, 370 or 380 voters. Whereas Rep. Cooper Busa district goes from being over, like having too many voters, to going to, 126 to being, too many by about 75. And so this provides some opportunity here to
Muddy the water.
rebalance. Well, yeah, as I said, it's a complex matter. And I think what I'm trying to present you with is what I think are not, they're pretty solid defensible positions that you as a body can stand on.
Representative Hooper.
Quickly, the 4 injury claims, Cooper, Booth, Pownell.
Sorry, oh yeah, the petitioners, Greensboro, Stanford, Pownell, and Pownell 45 and Busa.
Okay,
Yeah, so those are the 4, and they all had various claims that basically said, they talked about their remedy in their petition, but I think the underlying claim is that was this inaccuracy in the checklist. But the remedy they wanted was to make it right and make their votes count, make everyone's votes count. And I think redistricting does that.
Any further questions? All right, thank you, Counselor. That was presentation. Thank you.
I told you you could have cut me out sooner if you wanted.
No, I did.
Yeah.
I wanted to do all of this.
All right.
Yes, and I even baked a little overage into our map. So with the 3 o'clock. Legislative council. Table Jones.
All right, good afternoon, Tucker Anderson, Office of Legislative Counsel. Since both the House Clerk and Attorney Buxton kindly set the table by describing their roles, that's probably an appropriate place for me to start, since this is my first time testifying on this particular issue. So in this matter, I am your attorney. I represent you. I don't represent either of the parties that are requesting particular remedies from you. I am only here to provide you with legal advice on the issues that are raised in front of this committee. You can reach out to me individually. You can ask questions on the record. However you feel comfortable approaching those legal issues, I am here for the analysis and response. So within that setting, one of the things that I wanted to make sure that I didn't do today was venture too far into issues, since you have not heard from both of the parties yet. And I do not want to disadvantage either of them by providing legal analysis that could be used in front of you at a later time, or to appear unnecessarily adversarial in my testimony when it comes to the arguments that are raised in front of the committee. Another piece of place setting that was established today was that this is not a court, and some of the arguments were prefaced by, if this was a court, we would proceed in this manner. You are still a tribunal that is reviewing a contested matter. So I will proceed at all times as if that is the case. I will not talk about any of the particular pleadings that are made here that don't have legal claims tied to them. Really just tuck into 2 things that when I was reading through this particular memo stuck out to me as assertions about the limitations of your authority and power. And as your Doberman, my ears pinned back immediately on a few of these things. So I wanted to touch first on something that Betsy already covered, in very certain terms and with great legal analysis in her testimony, which is if you want to go in this direction, the power to structure a special election. So one of the claims that you heard was that the Constitution would not permit or allow you to conduct or order a second special election. In the legal research that I did around this claim, I was unable to find a single case decision in this state or in the 48 other states that have the same constitutional provision about the judgment and election of members that would support that claim. In fact, the history and context around the adoption of those constitutional provisions and the practice of many other legislatures would indicate the opposite, that you do in fact have the constitutional authority, if it is what you would like to do, to order a second election. I asked the chair for permission ahead of time, and I know that my time is especially brief right now since you have to head to the floor very soon. But I did ask for permission to briefly dip it into history to give you a little Tuckerism. So if we can jump into my time portal.
Give away, council.
We will go back to 1586. 1586 is the first instance that what was known as the privilege of a parliament to judge the qualifications and elections of its members. In fact, that was the name of the writ that was executed by the House of Commons in 1586. And it related to 2 seats in the county of Norfolk and the election of the Knights of Norfolk to the House of Commons. And the Court of Chancery at the time did not like the results of that election, and they ordered a second election. And the House of Commons stepped in and said it is not for the Court of Chancery to determine the outcome of either one of these elections. It is up to the House of Commons to determination the seating of its own members. What was glaringly absent from what the House of Commons asserted for the first time in 1586 was any notion that the second election was invalidly authorized or executed. It was just that the judgment of the qualifications and election of the members of the House of Commons was reserved to the House of Commons. And it was notoriously repeated in 1604, which is the most often cited case at the beginning of the privilege of parliamentary body to judge the qualifications and election of its own members for the Knights of Buckingham. And in that case, there was a special election ordered. Betsy and I could provide to you the dozens of instances in the United States Congress where special elections have been ordered either for the failure of a congressional district to elect a member or for a contested election. But the most brief way to state this is that you have the power. The other warning that I wanted to throw out there about some of the legal assertions, particularly around reapportionment and those constitutional provisions, is that the standard of review and the basis for when there could be a future challenge to the reapportionment of a legislative district is largely based on whether or not there is a rational basis for the design of the district. You know, if all things being considered with the demands of the United States Constitution around the apportionment of a district are satisfied, the court is going to defer to the decisions of the General Assembly so long as there is a rational basis for the design of that district. For the reapportionment process, this committee and the General Assembly amassed a whole heaping pile of evidence about why to go in the direction you went in. You took testimony, you heard proposals from the Legislative Apportionment Board. You heard the arguments of individual municipalities, divided districts. You printed off many maps. The reason I know that there was a whole heap of evidence that went into those decisions is because I have to preserve them for eternity in my office. Some of the maps I've put on my wall, many are rolled up in tubes and marked keep forever. So with that in mind, if you head in the direction of redistricting under discretionary constitutional authority, be prepared to accumulate the same evidence, conduct similar investigations, and build the rational basis for making that decision. Moving forward, I think it would be helpful if I could prepare for the committee just based on some of the early pleadings that you're seeing and what you may hear in the future, an explanation of the Title 17 statutes related to, for example, the creation of the voter checklist, some of the timelines associated leading into the election or challenges to the voter checklist, the Board of Civil Authority, and other statutory background behind some of the pleadings that you're seeing. Would that be helpful?
I think that would be a useful resource as we wrestle with these decisions. Representative Hooper of Burlington.
Going back a step, giving deference to the piles and piles that do not destroy material that you have, would we have to make a finding that other than a mistake having been made that shouldn't have been made, that would then have to justify the argument to redistrict if the line were to be redrawn? We would have to overturn the decision to then overturn the decision?
No, but you would need to proceed with a similar level of evidence and have a basis for redrawing the line. That's the very
Everything that
wordy
we went
non-answer
through
for you.
to draw the line in the first place, within normal percentages, et cetera, would be
Exactly. Make sure you keep the balance.
relevant to other lines we've drawn.
Okay, lot to digest. Thank you for keeping that brief, sir.
I could have gone longer.
No, I know, and I look forward to doing more of this with you, but
440 years of parliamentary history to go through. We only covered 1586 to 1604.
just a bit of an amuse-bouche on that one, huh? It's a little salmon canapé.
411 years to go.
The one part that I left out is that in the formulation of the early constitutions, including the Pennsylvania Constitution, which is where we got all of our constitutional language from, with some very minor changes. They were all aware of particularly the Buckingham case. So the language that is used around the judgment, qualifications, and elections of members is taken directly from that 1604 House of Commons assertion. Pull a little bit of a Marbury v. Madison. They just kept saying this is our power until it was.
Like a parliamentary deep cut.
I'd move that we disregard the call to the floor and sit and listen to this.
I was toying with that idea. I mean, there's like not much going on.
No, we have to go.
I do not want to agitate the office. So with that, thank you, Counselor.
I think that's a wise choice.
I'm more measured now. All right, that was a lot to take in. So we're gonna go offline now, digest. We did put another email out to Mr. Busa to see what scheduling availability is. I have not checked my emails since this started, but I don't think it's got back to us yet. So we left some gaps in the schedule tomorrow and Friday to speak to more folks. But I really want to try and line him up as soon as possible. That's why you're not seeing anything scheduled right now for this.